Hey everybody, welcome back. I hope you're doing well out there. We've just witnessed something that could reshape the entire conversation around so-called assault weapon bans in this country. Just a few days ago at 2 p.m., the Department of Justice stepped into the courtroom of the Seventh Circuit and did something that, to my knowledge, has never happened before. They showed up to argue in support of the Second Amendment, not against it. And this all ties back to an executive order signed earlier this year by President Trump. An order that many of us wondered if it would actually mean anything. Now we're starting to see the results. For years, administrations of both parties used the Department of Justice to defend gun control laws and argue that the Second Amendment could be treated as a second-class right. That pattern changed on February 7, 2025, when President Trump signed an executive order directing federal agencies, including the DOJ, to treat the Second Amendment as a full constitutional guarantee. No more excuses. No more carving out exceptions. At first, some dismissed the order as symbolic. Yet, here we are in late September, and the DOJ has carried that directive into a federal courtroom. An executive order does not rewrite the Constitution, but it does guide how the executive branch enforces the law. This one gave the DOJ a clear mandate to stop defending bans and start protecting the rights of Americans under the Second Amendment. That is why the recent hearing matters. It wasn't just paperwork in Washington. It was the top law enforcement agency in the nation telling a federal court that semi-automatic firearms and standard magazines fall under constitutional protection. The broader legal picture makes this even more important. Across the country, multiple challenges are underway, and 3 cases are already pending at the Supreme Court. 2 target magazine bans, while another challenges state prohibitions on semi-automatic rifles. At the same time, lawsuits continue in New Jersey, California, and Illinois. And it is Illinois that brought us to this pivotal moment. Back in January 2023, Illinois passed the Protect Illinois Communities Act, or PICA. The law banned the sale of many semi-automatic rifles and restricted magazine capacity beyond what most people already own. From the start, critics said it ignored the Supreme Court's Bruin decision from 2022, which required any gun restriction to be rooted in American history and tradition. Needless to say, there is no historic tradition of banning ordinary semi-automatic rifles or common magazines. In April 2024, UC's District Judge Stephen McGlynn struck down PICA as unconstitutional. He wrote that the Second Amendment protects arms in common use, and millions of Americans own the very rifles and magazines the law tried to prohibit. The state appealed, and the fight moved up to the Seventh Circuit in Chicago. That is how the consolidated case known as Barnett v. Raoul landed before a panel of appellate judges earlier this week. Barnett v. Raoul is more than another lawsuit. It is the centerpiece of the national debate. The Seventh Circuit has a reputation for siding with states on restrictive gun laws, and many expected this to be another uphill battle. But the dynamic shifted when the Department of Justice announced it would not only file briefs, but also argue in person against Illinois' ban. That move transformed the case into a test of how far the federal government is willing to go in defending Second Amendment rights. So here we are, late September 2025, with the DOJ now on record declaring that magazines and semi-automatic rifles are protected by both the Constitution and Supreme Court precedent. That alone is groundbreaking. This is not just private plaintiffs or advocacy groups making the case. This is the federal government itself stepping forward in a federal courtroom, creating a record that will matter for years to come. What makes this moment even more remarkable is who actually delivered the arguments. The Justice Department was represented by Harmeet, Dhillon, the Assistant Attorney General leading the Civil Rights Division. Earlier this year, in April, she was confirmed by the Senate after a heated debate. And since then, she has quickly become one of the most outspoken defenders of the Second Amendment ever to hold that position. This is not a minor role. The Civil Rights Division has long been known for advancing voting rights cases, discrimination cases, and civil liberties cases, but it has never been a division where the leader stood up in court and declared the Second Amendment equal to every other right. That alone would have been newsworthy. But Dhillon did more than that. She personally took on Illinois' sweeping ban. Her track record explains why this is so significant. Even before taking on this role, she was vocal about the way states like California imposed excessive fees and endless delays on carry permits. She filed briefs against New Jersey's attempts to block lawful ownership with blanket bans. And now, as head of the Civil Rights Division, She is using the full authority of the Department of Justice to say that magazines and semi-automatic rifles are not only common, but constitutionally protected. This is the first time the DOJ has openly said in a courtroom that the Second Amendment is not a second-class right, echoing the language from the Supreme Court's own decisions. When you look at it in context, this really is historic. In previous administrations, the DOJ routinely filed on the opposite side. They defended restrictions, they argued for limits, and they told courts that states had broad authority to regulate firearms as they saw fit. Seeing the very same institution flip that position on its head marks a turning point. It is not just about this one case in Illinois. It signals a shift in how the federal government might approach gun rights across the board. Now, let's talk about what comes next, because the possible outcomes at the Seventh Circuit matter tremendously. If the Seventh Circuit sides with the state of Illinois, declaring that PICA's bans are constitutional, that will not be the end of the story. Having the Department of Justice's arguments on record means those words will carry forward into the inevitable appeal. Every line of Dhillon's oral presentation, every point raised about common use and constitutional protection will be preserved, and when the case eventually reaches the Supreme Court, those arguments will already be part of the legal record. On the other hand, if the Seventh Circuit decides to side with the plaintiffs and strike down Illinois' ban, the outcome could be even more powerful. That would create what lawyers call a circuit split. Put simply, a circuit split happens when one federal appeals court rules one way while another federal appeals court rules the opposite way on the same issue. And when that happens, the Supreme Court is far more likely to step in, because it cannot allow constitutional rights to mean one thing in one part of the country and something entirely different in another. Think of it like a sports league. If two referees call the same play completely differently, the league office has to step in and settle it. That's what the Supreme Court does when circuits split. And that's exactly why this case matters so much. With the DOJ now arguing against bans and supporting the idea that semi-automatic rifles and magazines are protected arms, any split among the circuits would almost guarantee Supreme Court review. Either way, the presence of the Department of Justice changes the landscape. If Illinois wins here, the fight moves upward with the federal government already on record against the ban. If Illinois loses, we are one step closer to a Supreme Court showdown that could finally resolve these questions nationwide. That's why so many eyes were on that Seventh Circuit courtroom just days ago, and why this executive order from February is proving to be more than symbolic words on paper. It has turned into federal action with potentially national consequences. Looking ahead, the implications for the Supreme Court are enormous. Everyone watching this case understands that the Seventh Circuit's decision will not be the final word. One of the main reasons the Supreme Court takes up a case is when lower courts disagree. If the Seventh Circuit rules differently from other circuits, that creates what lawyers call a circuit split. And when that happens, the Supreme Court almost has no choice but to step in. It can't allow constitutional rights to be interpreted one way in one part of the country and the opposite way somewhere else. This matters because several circuits are already handling challenges to magazine bans and semi-automatic rifle restrictions. If one circuit upholds those bans and another strikes them down, the conflict becomes undeniable. The Supreme Court has made clear in the past that it will intervene when rights are fractured by geography. That's exactly how landmark cases make their way to Washington. And now, with the DOJ on record opposing these bans, the momentum toward a Supreme Court showdown feels stronger than ever. The precedent from the Bruen case in 2022 still looms large. That decision said the government cannot invent modern-day restrictions without pointing to a historic tradition of similar laws. In plain English, if there was no widespread tradition of banning common firearms in the 1700s or 1800s, then states cannot suddenly do it today. That standard has already reshaped Second Amendment litigation, and it will guide the justices again when they evaluate these bans. With the Department of Justice itself affirming that semi-automatic rifles and magazines are arms in common use. It aligns directly with the reasoning in Bruen. Now let's step back and reflect on why the DOJ's role here is so historic. For decades, gun owners have faced a Justice Department that lined up against them. Under previous administrations, DOJ briefs regularly defended state restrictions, urged courts to uphold bans, and argued that the Second Amendment should be narrowly applied. The culture within the department leaned toward treating gun rights as exceptions rather than guarantees. That changed when Harmeet Dhillon walked into that courtroom. for the first time. The Civil Rights Division itself, the very division tasked with protecting constitutional rights, stood up and said the Second Amendment deserves equal respect. This is not a minor shift in tone. It is a complete reversal of how the DOJ has traditionally positioned itself. Seeing the nation's top law enforcement agency embrace the idea that citizens have a fundamental right to own the very firearms Illinois tried to ban is something many thought they would never see. It matters on three levels. Legally, it creates a powerful record that other courts can cite. Politically, it signals that the federal government is no longer automatically aligned with states that push bans. And culturally, it sends a message to millions of law-abiding gun owners that their government is willing to defend their rights, not just restrict them. That combination makes this moment historic. So, as we close out September 2025, the path forward is clear. The Seventh Circuit will issue its ruling, and regardless of the outcome, this fight will climb higher. If Illinois wins, the DOJ's arguments remain in the record, ready to fuel an appeal. If Illinois loses, we move one step closer to the Supreme Court resolving this issue once and for all. Either way, the presence of the Department of Justice has changed the game. I can't emphasize enough how rare this is. We have never before seen the DOJ participate in oral arguments at a circuit court to defend the Second Amendment. It is unprecedented. It is historic, and it will be remembered as a turning point. This is not the end of the battle, but it feels like the start of a new chapter where the weight of the federal government is no longer against the people's rights. But for them, thank you for following along with me on this. These are the kinds of developments that can shape the future for decades. We'll continue to watch closely as the case moves forward and as the Supreme Court decides whether to take it up. I appreciate you being here, staying informed, and supporting the conversation. This is history unfolding before our eyes, and I'm grateful to share it with you.